Good afternoon, everyone. Can everyone hear me?
Yes, we can.
Very well.
And everybody, it is just about 3:30. Are the justices need any additional time? No. Okay. Hearing none, I will go ahead and ask the marshal to call this matter to order.
Thank you.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, everyone. I am Chief Justice Inman, and I'll be presiding over this panel this afternoon. We have one matter on our docket, case number 2021-2022, William Denoff, petitioner versus the United States of America, respondent. And I will just ask the other justices to introduce themselves so you can know the names of each justice. And then I'll ask each speaker to identify your team number and your names.
I'll start off, Justice Carey.
I'm Justice Burke.
Justice C.
Justice Lamar Baker.
And how about counsel for the petitioner? We can hear from you first in terms of just your team number and your name, so we can get that for our notes.
Yes, we're team number 101. On issue 1, I'll be arguing Lily Hong.
And I'm Donna Borstein. I'll be speaking on behalf on issue 2.
Donna Warsheim?
Borstein, yeah.
Borstein, thank you. And for respondent.
Your Honors, respondent is team 308. My name is Vishali Chaudhary. I rise on behalf of the people of the United States, and I will be addressing the first issue for 10 minutes.
Very well. Very well.
Madam Chief Justice, my name is Marco Romero, team 308. I'll be addressing the second issue of substantive due process, and I'll speak for a total of 10 minutes as well.
Very well. And counsel, you're keeping your own times. Just so you know that you're not relying on any of the justices here to keep time for you, right?
I believe we have a marshal available to do that.
Yeah. Your Honor, I'll share the screen with the time.
Thank you. Thank you very much. I think that's helpful to everyone. Well, with that, we will now hear from the petitioner.
And before I proceed, Chief Justice, may we reserve 3 minutes for rebuttal?
Yes, you may.
And maybe we proceed.
Yes, you may proceed now. Thank you.
Chief Justice, and may it please the court. My name is Lily Hong, and I, along with my co-counsel, Donna Borstein, rise on behalf of the petitioner, Mr. William Denoff. I'll be addressing the first issue, how Congress exceeded its Commerce Clause authority in enacting the Polio Vaccination Act. And my co-counsel will be continuing on with the second due process issue. Your Honors, this case is about maintaining the appropriate role for Congress in order to prevent unending expansions to the federal government under the guise of commerce. This court should reverse the decision of the lower court for the following 2 reasons. First, the PVA regulates a class of individuals and their inactivity rather than a class of activities, and it therefore exceeds Congress's Commerce Clause authority. And second, the PVA fails the rational basis test and is therefore unconstitutional under the Commerce Clause. To the first point, the PVA regulates a class of individuals rather than a class of activities, and it therefore exceeds Congress's Commerce Clause authority. As written in Article 1.
Listen to the activity, the taking of the vaccination.
Your Honor,
that was regulated?
Your Honor, that is what the PVA is compelling in this case. And instead of it regulating some specific activity of those who are included in the regulation, it instead compels an activity rather than regulating it. And it's
Well, has your argument ever been endorsed by a majority of the Supreme Court?
No, Your Honor. But in Perez versus United States, this court did determine that those cases that fall under the Commerce Clause are those of channels of interstate commerce, instrumentalities of interstate commerce, and activity.
Ms. Hong, can I ask you about sick leave? Can Congress pass a law that requires any employer who employs more than 50 employees to provide 3 weeks of sick leave for its employees? Is that within Congress's power?
Yes, Your Honor, that is within.
So why is this vaccine mandate any different? In other words, what Congress is trying to do is to make sure that people who are working across the United States continue working so the economy keeps running. And so if you agree that Congress can mandate sick leave so that employees who get sick get paid, why don't you think Congress can mandate a vaccination that will keep everyone working and keep the economy going?
Your Honor, the difference between the PVA's regulation and vaccination mandate and sick leave ultimately comes down to who is included in the regulation. And if the PVA did only apply itself to those who are working and engaged in interstate commerce through their work, then it would fall within this commerce power. But because the PVA goes further than that and includes people simply because their health alone affects commerce, regardless of any activity they've engaged in interstate commerce, it means that the PVA goes too far. And that's beyond what this court's precedents have said, even in far-reaching cases like Wickard versus Filburn. Even in Wickard, there was.
I'm sorry. If you can just articulate a little bit in more detail how the PVA goes further than sick leave in affecting a broader group of people. I just want to make sure we're on the same page.
Your Honor, it goes farther than sick leave because it isn't applied to people simply because they are in the workforce. And the definition of engaged in commerce in the PVA in Section 4 of the record means that it also includes those activities or people whose health affects commerce. And the idea of people inherently having health and that health affecting commerce makes people inherently economic in a way that this court has not allowed for under the Commerce Clause precedent.
Counsel, am I understanding correctly that if all of the facts were the same, except that the mandate were limited to individuals who worked somewhere where there were, say, at least 50 employees, like Justice Baker's hypothetical, you would not be challenging it in that case?
We would not be challenging it under this Commerce Clause issue, as it would have a jurisdictional element and be limited to a specific activity that people were engaged in.
But why does the location matter? We're talking about a pandemic that necessarily crosses state lines. It certainly crosses the lines when you leave your workplace. Why should location be the constitutional determining factor?
Your Honor, it's not the location of the workplace per se, but rather the idea that being at work and actively engaging in some economic activity that affects the economy is something that is within a commerce power. But because vaccinations are inherently non-economic and the PVA fails to include an economic nexus that this court required in cases like United States versus Bass, as cited within United States versus Lopez, and United States versus Morrison, because that is lacking in the PVA today, it goes beyond what this court has allowed. And so we're not asserting that there's no ultimate cause or effect on the economy due to a polio pandemic. The ultimate problem comes down to this issue of jurisdiction and scope. And so even
hypothetically, if I could just ask you, let's just say you have a one-person accounting office, an accountant who works by themselves, but they got clients coming in all day long, and they've got representatives of their clients coming in all day long. They could have a very, very crowded office in any given day, just with their customers coming in. Doesn't that affect commerce, even if it's just a one accountant working by him or herself?
Yes, Your Honor. And we would assert that that person should be included in the PVA if it had been drawn to a correct jurisdiction. The problem with including Mr. Nolf is that he does not engage with people in every day in his work. And the ways that he engages in the interstate economy does not affect his health.
Can I just ask you a little bit about what the record says on that? Because at least as I understand it, your client gets deliveries from Amazon and other services every day. He goes to the bank, he goes to the post office, he gets fantasy baseball stuff sent to his house, or people come over to deliver it. That looks like quite a bit of activity to me. Am I getting the record wrong?
No, Your Honor, that is what the record states. And on page 4, we concede that Mr. Nolf engages in the inter and intrastate market. The problem ultimately comes down to the fact that engagement in the marketplace, as defined by the PVA, includes this broad meaning of health affecting commerce. And so that implies Mr. Denolf, as well as every single person in the US. Additionally, Section 4D of the PVA establishes that newborns should be included within this jurisdiction. And so there's no way in which newborns who are included in the PVA's regulation can engage in some specific activity that is economic in nature that has an effect on the economy ultimately. And
Counsel, does your argument somewhat cut against Wickard and Raich in that when we talk about the aggregate effect on the economy, as opposed to just this individual person?
No, Your Honor. And in Wickard versus Filburn, there was this existing activity of farming, and it did have an aggregate effect. And we're not assuming that there's no aggregate effect here. It ultimately comes down to that lack of activity that was there in Wickard, but isn't here today. In Wickard, there was this Agricultural Adjustment Act that placed a limit on the existing activity of farmers, and therefore there is that quota. Here, there's no limit or qualifying or conditioning of any activity that pre-exists, but instead a compulsion of new activity. And it's dissimilar from that of Gonzalez versus Reich, because ultimately that was a broader regulatory scheme. And today the PVA is quite literally the
So counsel, you concede that there is an aggregate effect here, and you concede that your client engages in commercial activity of some sort. So the only distinction you're raising is that this is inactivity versus activity. Am I understanding that correctly?
No, Your Honor. In addition to this problem of activity and inactivity, there is also the jurisdictional problem of state police powers. And in the case of United States versus Morrison, this court was similarly looking at the regulation of crime, which is the state police power, similar to that of public health, which Whalen versus Roe, as cited within Justice O'Connor's.
But if this is a jurisdictional issue, you were just explaining earlier that you agree that your client does engage in commercial activity. He doesn't go to a traditional workplace, but he still goes to the bank and participates in commerce. So isn't that jurisdictional element satisfied? That's interstate commerce. That's right in the Constitution.
No, Your Honor, solely because this court should consider the question of whether or not a regulation destroys that distinction between what is national and what is local. And so here, because the PVA fails to distinguish truly between what is intrastate and what is interstate, and does so while regulating the non-economic activity in a state police power, which is public health, it goes beyond just that which the federal government should be able to do and would overturn that of Morrison and United States versus Lopez. And so for these reasons, we ask for this court to reverse the decision of the lower court. Thank you.
Thank you, Ms. Hong.
Your Honors, may I proceed?
Yes.
Chief Justice, and may it please the court. My name is Donna Borstein, and I will be continuing argument on behalf of the petitioner, Mr. William Denolf. I'll be addressing the second issue regarding how the application of the Polio Vaccination Act to Mr. William Denolf is a violation of his Fifth Amendment rights to due process. Your Honors, in times of crisis, the first thing that the government does away with should not be our fundamental rights. Instead, this case is about preserving individual liberties in a time when the government has other
So are you
priorities.
saying that there is a fundamental right that's been recognized by the Supreme Court against a vaccination?
No, Your Honor, I am not contending that there has already been established a fundamental right.
All right, so you're asking us to do that.
Yes, Your Honor.
Okay.
And in this case, it would be logical to make that conclusion because we can derive that right from the history that this court has established in the past. And therefore,
Are you relying on Cruzan as one of those cases?
yes, Your Honor. However, this is not the same type of issue as was at bar in the case of Cruzan versus Director, Missouri Department of Health, but rather the same type of history and precedent that Cruzan relies on to derive its own fundamental right is the same history and precedent that this court should use to derive Mr. Denolf's more specific right to refuse vaccination.
Counsel, I'm puzzled by the idea that you argue history is on your side because the Jacobson case squarely rejected that argument.
Respectfully, no, Your Honor. Jacobson versus Massachusetts did not reject the idea that there may be a fundamental right to refuse vaccination, as Jacobson predated altogether the history and understanding of substantive due process that this court uses. In fact, in the case of Jacobson versus Massachusetts, the court did acknowledge the liberty interests of the petitioner in that case in refusing vaccination. And this court has taken that as its legacy, as in Cruzan, when the court evaluates a long history dating back to English common law of medical refusal, it includes Jacobson versus Massachusetts in that precedent.
Ms. Borstein, I feel like we might be getting a little lost in the weeds here. What's the holding of the Jacobson case?
Yes, Your Honor. In the case of Jacobson versus Massachusetts, the court determined that Massachusetts could create a regulation under its police power to mandate a vaccination in that state. However, here, that does not contradict the fact that this court can still derive a fundamental right, as the history that even this court has understood from Jacobson is that it did acknowledge an idea that an individual can refuse vaccination, but simply that the government interest in that case pervaded over those specific liberties.
I'm unclear
So,
about.
so just, I'm sorry to interrupt. So just Jacobson is still good law, correct?
Yes, Your Honor, it is. And
It
it doesn't.
hasn't been reversed, hasn't been overturned.
No, Your Honor. And that does not mean that it contradicts the case at bar, however. For instance, in the case of Cruzan, the court evaluated a number of cases in order to derive Nancy Cruzan's specific fundamental right. And in doing so, it cited even cases that went against the right that Nancy Cruzan asserted of life-sustaining hydration and nutrition, like Henry Quinlan, but used them to establish at the very least that there was a history and principle that medical refusal was important in this court's tradition. And so too here, can we understand Jacobson versus Massachusetts?
Let's go back to Jacobson. It sounded like you were arguing the court in that case recognized a right that you still haven't quite articulated for us what it is, but I'm just wondering which way that cuts. In other words, you seem to be saying the court in Jacobson said, well, maybe you have some right to this, but you just told me the holding was, well, the state can compel you to get vaccinated. If anything, that seems like it's worse from your perspective. What am I missing?
Respectfully, no, Your Honor. The fact that the governmental interest in that specific case where there was a smallpox outbreak that was already ravaging the population in Cambridge at that time outweighed the interests of the individual does not cut against this case, as here we would still evaluate a strict scrutiny standard of review to consider the government's interest. However, the fact what's compelling in Jacobson versus Massachusetts is that it does establish that an individual does have this history and understanding that they can make a decision. And that's something that this court has considered later. And though it did not establish that there is a fundamental—
Still haven't reckoned with the point, which is that history lost in that case.
No, Your Honor, because in that case, though it established in that one specific circumstance that the government create a mandate, this court itself has cited back to Jacobson as a circumstance that acknowledged the history of refusal and includes the ideas of vaccination within that history of refusal, meaning that today deriving a fundamental right to refuse vaccination would be legitimate. And therefore, based off of the precedent in Washington versus Glucksberg, citing the case of Reno versus Flores, where there is this fundamental right, there is a need to use a strict scrutiny standard of review to evaluate.
Tell us.
So you're saying, go ahead, Justice, sorry.
Chief Justice goes.
You just asked for strict scrutiny review at this point?
Yes, Your Honor.
I just want to hear about that.
Yes, perfect. Yes, Your Honor. In this case, strict scrutiny should be applied based off of the precedent in Reno versus Flores, as cited in Washington versus Glucksberg, which asks simply that there be a compelling interest and that the PVA would be narrowly tailored to that interest. We concede in this case that there is a compelling interest in preserving life in the United States for the government. However, the PVA is not narrowly tailored because it addresses a threat that is not yet in the United States and does it in a way that interacts with an individual who rarely interacts with the United States at all. In this case, according to page 2 and 3 of the record.
Well, haven't we learned from COVID that the time to act is before it gets to the United States?
Yes, Your Honor, it is.
You're using that as one of the bases for why this violates due process, is that it's not in the United States yet. Is that right?
Yes, Your Honor, only in that the government needs to take the least restrictive means when it creates its policies. And so the government can take preventative action against polio, and it should. However, it does not need to do so in a way that regulates somebody like Mr. Denolf, who, according to page 5 of the record, interacts with the public so little that even his closest friend, Andrea Somerville, drops off things outside his home instead of coming in. And therefore—
Can you articulate for me as precisely as you can what the fundamental right is that you think is being violated as to your client? In the argument you've made some rather broad pronouncements about a right to refuse a vaccine, which presumably would include school children, and we'll go back to the days of measles and smallpox So I just want to understand what precisely is the right that you're advocating.
Yes, Your Honor, the right that I'm advocating here is the right to refuse vaccination. However, it is not a right that would overrule the ability of the government to make those sort of restrictions for school children that Your Honor mentions. In the case of Weimeister versus White, as cited in Jacobson versus Massachusetts, the court discusses the way that public schools are brought into the scheme of vaccination and understands that it is because of the specific contract and lower level of rights in those schools that students are able to go into an agreement with the school when they step into that schoolhouse to be vaccinated.
Counsel, what about the fact that this is not a simple medical refusal case? In an ordinary refusal of treatment case, the only person who's potentially hurt is the patient making that decision. Here we have a situation where someone refusing care is putting many other people in the country in danger. What is your best support that the fundamental right extends that far?
Chief Justice, I see my time is about to
I'll
elapse.
allow you to answer this question very briefly.
Thank you. Your Honor, in the case of Washington versus Glucksberg, this court established that fundamental rights are a threshold question. And where an individual is able to make a choice, we must reach that threshold first and then determine if the government passes strict scrutiny, where we could weigh those interests of other individuals that Your Honor mentions. Therefore, in this case, because it does not pass strict scrutiny, we ask this court to reverse. Thank you.
Thank you very much. We'll now hear from the respondent, the United States.
May I proceed, Your Honor?
Yes.
Thank you. Madam Chief Justice, Associate Justices, and may it please the court. My name is Vishali Chaudhary, and I, along with my co-counsel Marco Romero, rise on behalf of respondent, the people of the United States. I address why the Polio Vaccination Act is a constitutional exercise of Congress's authority to regulate interstate commerce. This case is about protecting the government's authority to preserve interstate commerce by combating the spread of infectious disease. We ask this court to affirm the decision of the 14th Circuit and find that the PVA is constitutional because it regulates a class of activity that has a substantial impact on interstate commerce. Before proceeding to this argument, I'd like to address opposing counsel's contention that the jurisdictional element contained with the law is not narrow enough. Opposing counsel contends that the jurisdictional element, if more narrowly drawn, could have made the PVA constitutional when answering a question posed by Justice C. However, that goes directly against this court's ruling in Gonzalez versus Raich, in which this court explicitly noted that, quote, Congress is under no obligation to legislate with scientific exactitude. Instead,
Of course, in this case, they're really regulating a very small percentage of the American population. I mean, we're starting off with 90% of the population that's already been vaccinated, and then another, I guess, 7 of that 90% that would either have no symptoms or a few symptoms for a few days. Isn't this a little bit ham-handed on the part of the government? They're really going after a very small amount of people and calling that interstate commerce?
Well, Justice Carey, although it seems that 10% of the population may be a small percentage, the record reflects that that amounts to 32.8 million Americans who often live in clusters in rural and in urban cities.
Right, but 7.5% of them would be, if I look at my notes and get it completely accurate, about 7% of those would have no symptoms, and then another couple percent would have flu-like symptoms for a few days. So it really is a small amount of people that, relatively speaking, are affected. And my problem with the statute is that it goes right to mandatory vaccinations as opposed to a campaign to try and get people vaccinated or something lesser. Can you address that?
Of course, Justice Carey. I'll answer your question on 2 points. First, the finding that the government makes was that there was a pandemic and the potential for a polio pandemic. And that word, the pandemic, is defined by the PVA in Section 2A6 as a disease and the spread of a disease that could cause up to 25,000 deaths annually without a mandatory vaccination act. Additionally, although it's true that currently there may not be the spread of polio within the United States, what the record does reflect on page 2 is that the National Pandemic Preparedness SAR notified the president that there was, quote, a great likelihood that individuals with the polio virus.
So to what extent are we required to rely on congressional findings. We can certainly, I think we should review them, but we can certainly decide whether or not we think those are appropriate. Isn't that right?
Yes, Justice Carey, that is correct. And opposing counsel cited United States versus Morrison when asking this court to reject the congressional findings here. However, there are two key distinctions between the Violence Against Women Act at issue in Morrison and the PVA in the present case. That first issue is that the Violence Against Women Act did not include a jurisdictional element at all, whereas here a jurisdictional element is contained and does limit the law only to individuals who engage or affect interstate commerce. And second, that in Morrison, the violent criminal activity that was being regulated had an attenuated connection to interstate commerce. However, here, what's being regulated is the spread of infectious disease, and its nexus between that activity and interstate commerce is firmly established. What the record reflects.
So I want to take you back to where your friend on the other side ended. It seems the real concern here is that if the federal government is correct, then we have destroyed the balance between what's national and what's local. What's left of state authority under your rule?
Justice C, this gets to a fundamental flaw in opposing counsel's argument, which is that the PVA does not destroy that distinction between what is truly national and what is local. Rather, it's entirely consistent with what this court set out in Wickard versus Filburn and in Gonzalez versus Raich. In both of those cases, what was at issue was non-commercial local activity. However, this court aggregated the impact of that activity and found that when the total instance of a particular class of activities has a substantial impact on interstate commerce, the Commerce Clause gives Congress the authority to regulate that entire class.
But counsel, I think my concern is in today's economy, you could make that argument for almost anything that Congress would want to do. So it seems if we're going to preserve any meaningful limits on the Commerce Clause, the fact that public health and vaccinations have historically been within the state's power seems to be a really powerful argument against your position. Why shouldn't we uphold that traditional line?
Your Honor, that concern is of no moment here because the PVA itself includes limiting principles. Section 2A7 of the PVA defines what an economic impact on interstate commerce would be, that impact being either that the GDP decreases by 1% or the unemployment rate increases by 10% or more.
Well,
Now,
that's really just speculation, though, isn't it?
No, Your Honor, what the record reflects is that the executive and legislative branch have concluded that the danger of that economic emergency does exist. And those kinds of dangers cannot arise from the kinds of concerns that this court had in National Federation of Independent Business versus Sebelius. The dissent cites that case and its concern that if Congress was able to use the Commerce Clause power to regulate activities that have an attenuated connection to commerce, that would transform.
That's really the concern in this case, isn't it, right? I mean, we want to prevent the Commerce Clause from turning us all into the Matrix, where the government gets to decide what medical procedures we have, how much salt we get to eat every day to make us optimal employees to run the economy. That's not America. It's never been America. And it seems like if we accept your position, then we open the door to the government having more and more intrusive methods brought forth in the name of national unity and worker wellness. That seems like a problem, no?
Jumping on to Justice Baker's point, the record indicates that from 1979 to 2020, polio was eradicated in the United States, and that was done without a vaccine. Isn't that something that should be considered? Or without a mandatory vaccine?
Justice Baker, I'll first address your concern and then move to yours, Justice Carey. Starting with your concern, Justice Baker, here, the principle that there be a separation of powers and that Congress not exceed its authority under the Commerce Clause is not harmed if this court were to find in favor of respondent, because the flaws that this court has found with an attenuated argument in connection to commerce that the government put forth in Lopez and in Morrison do not exist in the present case. In those cases, the costs of crime and productivity arguments advanced by the government relied on inference piled upon inference. But in the present case, there aren't inferences, but simply facts in the record that show that the Congress was rational in coming to the conclusion that the risk of a polio outbreak does exist and that it would substantially affect interstate commerce. Moving to your concern, Justice Carey, although it's true that polio has not been in the United States in 41 years, that does not mean that the government has no authority to take preventative actions to protect against current threats. What the record reflects on page 2 is that there are currently outbreaks of polio in 5 countries in major cities that have constant travel with the United States. Those individuals may have already entered the United States, as reflected on page 2. With individuals in this group of 32.8 million Americans who remain unvaccinated for one of the most infectious diseases in the world, what the record reflects about these individuals is that they often live in clusters. In these
Ms.
clusters,
Chowdhury, going back to the point we were discussing a moment ago, maybe you can give me an example of something that you think Congress can't do. In other words, I've outlined for you a number of concerns that I have about what this would open the door to. Maybe you could articulate something that you think is beyond Congress's power under the Commerce Clause when you're dealing with employee wellness or infectious disease.
of course, Justice Baker, for example, Congress cannot draw attenuated connections between the simple health of workers and the productivity of the economy. It cannot force workers to have a national sleep cycle, a national diet, or a national exercise plan. Of course,
How about mandating a vaccine against the flu?
Your Honor, the flu does not have a substantial impact on interstate commerce, and for that reason, Congress would be irrational in that action. Here, however, Congress is rational when taking a preventative action to protect 32.8 million Americans, and for that reason, we ask this court affirm the decision below.
Thank you.
May I proceed, Madam Chief Justice?
Yes, you may.
Thank you, Madam Chief Justice, Associate Justices, and may it please the court. My name is Marco Romero, and I rise to continue arguments on behalf of the respondent, the people of the United States. The government is entrusted with protecting the health and safety of its citizens. In the span of 1 year, the COVID-19 pandemic claimed the lives of more than 500,000 Americans.
Well, Mr. Romero, though, COVID is so much different than what we're talking about here. When COVID first came about to the United States in February of 2020, 100% of the people were not vaccinated. We didn't even know about when there was going to be a vaccination, and there was a lot of unknown. With regard to polio, it's been eradicated once, and there's less than 10% of the population that could even possibly be exposed to it. So don't you think that there really are two significant differences between the two?
They're different, surely, Justice Carey. However, those differences do not defeat the government's determination here that swift action was necessary in order to prevent a polio pandemic. And I have two responses that demonstrate this. The first is that although it is true that 90% of Americans are vaccinated against polio in the United States, what page 3 of the record demonstrates is that the remaining 10% is not de minimis. It's not a few hundred or a few thousand. It is 32.8 million Americans. This fact, in conjunction with the fact that polio, as page 2 of the record indicates, is one of the most infectious diseases known to mankind.
Well,
And
Mr. Romero, what if it were a few hundred? Does that mean your client is powerless to act?
the United States government, yes, Your Honor, the United States government could not order vaccinations if it was only a few hundred individuals. And it gets to what authority.
Mr. Romero, does the
like an awful utilitarian calculus?
Justice Baker, it isn't based on a utilitarian calculus, but rather upon what authority the president is ordering vaccinations. The president here is acting upon the authority delegated to the president by Congress's Commerce Clause power, which means that in order for the president to order vaccinations, it must demonstrate that a particular disease can amount to a pandemic level, because that is what has the substantial impact on commerce. That empowers the government to act. A state's police power could certainly perhaps order individuals to get vaccinated in those other instances. But here, given the constraints on the president's authority, the president must demonstrate a pandemic would ensue, and the factual record does in fact support this contention. The second key fact is that although more individuals are vaccinated against polio than of course were vaccinated against COVID, Appendix 1, page 18 of the record indicates that COVID-19 is up to 3 times as infectious, that polio is up to 3 times as infectious as COVID-19. That indicates that while there may be less people, the infectious rate will lead to disastrous consequences, just as those that occurred with COVID. Now, the government's authority here is strong under this court's decision in
I
Jacobson.
could just interrupt you. The disastrous pretty mild symptoms or no symptoms?
Madam Chief Justice, I only caught part of your question, but I think I understand the thrust of it. Yes, 72% of individuals, as page 3 of the record indicates, will get mild symptoms. However, the remaining individuals, the 28% of individuals, can suffer from, for example, paralysis, can lose the ability to lead independent lives because for 40% of children who are infected with polio will suffer from post-polio syndrome, which causes them to have difficulty breathing, to have difficulty eating, sleeping. And for 10% of individuals who are struck with paralytic polio, these individuals will lose their lives. There are 32.8 million people that are susceptible to this, and the government has the authority to protect them. What the petitioner argues here today is that this court's decisions and the history it has looked to supports this court according the right to refuse a vaccine fundamental status. But Justice C's question to the petitioner about Jacobson indicates exactly the opposite.
Well, counsel, let me ask you this. I mean, is there a federal police power? Because when the appellate majority was discussing Jacobson, in a footnote, it said that there's no difference whether this was a state authority or federal authority. So is that a recognition of a federal police power?
It isn't, Justice Burke. It's true that the 14th Circuit found that there isn't a distinction, but that isn't because the federal government has a police power, but rather because the government is acting, particularly the president, under the enumerated authority that Congress delegated to it to protect commerce. And the reason that public health is implicated here is because the way that the government is protecting commerce is from preventing a pandemic and protecting public health. And this gets to—
I don't disagree that the standards that we have used to evaluate restrictions on individual liberties have changed dramatically since Jacobson. You're not challenging that, are you?
Not at all, Justice C. However, the line that this court drew in Jacobson, which is that an individual may have a liberty interest in refusing a vaccine, but an individual does not have an interest in refusing a vaccine when doing so brings harm to others. And this is telling that this court has not departed from that particular analysis. The petitioner cites heavily to the case of Cruzan, but Cruzan itself cited to Jacobson versus Massachusetts. This court has deemed the right to refuse a medical treatment as a liberty interest, not a fundamental right. And there's a reason for that. And it gets to the question posed by Your Honor, Justice C, to the petitioner, which is this is not the run-of-the-mill medical treatment refusal. There is a key and constitutionally significant distinction between refusing medication or a treatment, such as the right seen in Cruzan of food and hydration, where the harm that flows from that only affects the individual themselves. That is not true.
But how far does that go? What if we have a situation where there's medical evidence that with a particular diet or exercise regime, someone is 90% less likely to contract polio? And so in that case, we would have the same considerations about these personal decisions affecting the health of others. Would you argue that the federal government has the ability to mandate that diet and exercise regime?
No, Justice C, because there that issue would be much more attenuated. The issue of a diet, while it may have an effect on an individual's ability to contract polio in that exact hypothetical, would still be too attenuated. Here it's direct, and it helps to articulate a limiting principle.
But I think the way I'm setting up the hypo is to try to take away that distinction. Let's assume that a vaccine reduces your odds of getting polio by 90%, and that this hypothetical diet and exercise regime reduces your odds the exact same way. Does that change the liberty interest analysis?
It may, Your Honor, yes. The government wouldn't be able to prevail there because what a particular applicant could demonstrate is that there's another way for an individual to be kept from contracting polio, which would be less restrictive on them. And under the liberty interest analysis, the government must demonstrate that its interest is stronger than that of the individual. So perhaps the government would fail in that particular instance, Justice C. But here—
Counsel, in defining the liberty interest, are we looking at other people's health, or are we looking at the bodily integrity of the petitioner? Because it seems to me that if we're looking at other people's health, we're conflating the liberty interest at issue here perhaps with the compelling state interest.
Justice Burke, it isn't conflating, and this gets to a flaw in the petitioner's argument, which is the test itself that this court has articulated for whether a fundamental right should be found, requires that an individual demonstrate that the right being sought is deeply rooted in the nation's history and consistent with the concept of ordered liberty. Making a decision that only affects oneself, that is surely implicit in the concept of ordered liberty, but making a decision that harms others cuts directly against.
Mr. Romero, I understand you're making the argument that we're all in this together, and I get that. But on the other hand, I think this country also has a fairly strong tradition of individualism. And in particular, I wonder why, on your view, we ever needed the Prohibition amendments. I'm sure you could find evidence that suggests that people who drink are more likely to commit domestic violence and other crimes. And yet there was no thought that Congress could just come in and just start banning alcohol. No, we had to have constitutional amendments about that. And so I think you may be drawing the distinction or drawing the difference between we're all in this together, but yet we're all in individuals in a way that's inconsistent with our history.
Well, Justice Baker, it is consistent, and I'll attack the hypothetical first. There, with causing individuals from stopping them from drinking because they may have a higher likelihood of hurting other individuals, that again will not occur in every case. There is such a thing as safe consumption of alcohol. There isn't such a thing as a safe refusal of vaccine, particularly in a pandemic like
72% of people might disagree with you.
Yes, Your Honor, but the other individuals, particularly the 10% of individuals who will die as a result of that, they would likely find that the government's argument here should prevail. And the reason
presumably the same 10% that would be a victim of crime in my hypothetical.
Well, Justice Baker, this is the key limiting principle, that the government can't regulate every individual's decision that may harm others, but rather a decision that causes direct substantial harm. That is present here. The principle this court articulated in Jacobson is that liberty ends where harm to others begins, and we ask this court to affirm that principle here. Thank you.
Thank you very much for your comments. At this point, the case is submitted. And
We have rebuttal.
oh, we do allow rebuttal. I'm sorry. Please forgive me, petitioners. I forgot about your 3 minutes.
No problem, Your Honor. Thank you.
Didn't mean to scare you. Go ahead.
May it please the court. I will be continuing argument on both the first Commerce Clause and the second due process issues in this case. On the first Commerce Clause issue, counsel for respondent argues that this court should rely upon the cases of Gonzalez versus Rake and the case of Wickard versus Filburn, where individuals were able to be regulated on things that were not necessarily economic. But in both of those circumstances, there was a specific commodity and a specific activity that was being regulated that is outside of what the PVA does today, where it mandates vaccinations and an individual's decision to get vaccinated without any connection to an actual vaccine market, and therefore goes beyond what the court allowed in the cases of both United States versus Morrison and United States versus Lopez, where there was a required jurisdictional element. And while counsel for respondent argues that this jurisdictional element is
I wonder what you think about the military draft statutes, and in particular in connection with your fundamental rights argument. If the government has the power in the national interest to send young men and young women, or maybe young women in the future, to die on behalf of the country, why doesn't the government have the power to require those individuals to get vaccinated in the national interest? Or maybe you think the draft statutes are unconstitutional. You tell me.
No, Your Honor, do not contend that the draft statutes are unconstitutional, but rather that even in the circumstances of a draft for war, there has to be war, and it only happens in extreme circumstances. And in the case at bar, somebody like Denolf does not have any implication on the spread of polio in the way that counsel for respondent asserts. And so,
would you concede that if the numbers were different, if there weren't this mandate and the polio epidemic came to the United States, that you might have a losing argument here?
No, Your Honor, the only circumstance in which the government could not create a more narrowly tailored policy or a policy that under the liberty interest of Mr. Denolf outweighs the interest of an individual like him is if it can demonstrate that somebody like him specifically can implicate other individuals in a way that requires a mandate for every single individual in the United States when it has this piece of information. In this case at bar, even under a liberty interest, which counsel for respondent asserts is present in this case and does require a balancing test, balancing the government's interest in this case against the interests of the individual still allows an individual like Mr. Denolf specifically to prevail. Knowing all the facts we know now, the government could take other actions like travel restrictions or restrictions in public places, or even vaccine mandates on populations at high risk. But it does not need to regulate somebody like Mr. Denolf, who according to page 5 of the record, rarely interacts with the public at all. Your Honors, in times of crisis, rather than in times of calm, it is necessary for the government to preserve the limits that the Constitution creates for our government. And therefore, we ask this court to reverse. Thank you.
Thank you, counsel. Now the case is submitted. And the justices will virtually go into conference by silencing our audio and turning off our video. And we will be back with you shortly. Thank you.
Thank you, everybody. And that concludes our final championship round. While the judges submit their ballots, how about a round of applause for all our competitors? Congratulations, teams 101 and 308. The results will be announced at 4 o'clock Central Time. And at that time, we will be announcing the top orators, the best briefs, as well as the winner of the championship round. So you do have a little bit of time until then. Please feel free to take it. But this is the Zoom where the announcements will all be made, including all awards. See you soon.
I am sorry to have kept you waiting.
No problem. Would you like, why don't you go ahead
I
and
like to
start,
make
Chief
sure I have
Justice?
my comments from the ballot. Well, first of all, I want to just congratulate all 4 of you. I suppose it doesn't surprise me because we are in the final round of this competition, but each of the 4 of you handled yourselves with demeanor that in my view matches some of the best seasoned litigators, appellate lawyers I hear argue day in and day out in the North Carolina Court of Appeals. And I know that must have taken a tremendous amount of preparation. I'm going to make very, very brief comments, and I'm sure that the other participating judges will have more to add. Ms. Hong, you opened very strong. I realized as you got into your argument that even though this is a very, huge impactful case, your client is an individual. And if you just remember when you are the first to speak in a case like this, the more you can do to make your client and the case concrete and help us relate to that person, the more we're going to be following every legal argument you make with, well, how is that affecting him? How is that affecting him? Ms. Borstein, I hope I'm pronouncing your name correctly. You, like all 4 of you, really great mastery of the subject matter. Sometimes you know it so well. I think it's easy to forget that you're educating someone else about it, even if it's an appellate judge. When you talked about strict scrutiny, that's a really important distinction. And being able to draw a roadmap to how you got to that and what the consequences are for us is very, very helpful. Ms. Chaudhary, am I pronouncing your name correctly? Chaudhary?
Chaudhary, Your Honor.
Chaudhary. by the time you're speaking, now the judges are all warmed up. We're all educated on this, and we've got many, many, many more questions for you. I think you got more questions than Ms. Hong or Ms. Borstein. I may be wrong about that, because we were more into it, and you handled those questions well. At one time, you received questions almost simultaneously from Justice Carey and Justice Baker, and you stopped and you answered Justice Baker, and then you answered Justice Carey. And the fact that you could keep those two names straight and their questions straight showed me that you were really focused. And that was impressive to me. Mr. Romero, you had the benefit that the Appellee's Council is always going to have. And that is, you saw Ms. Borstein struggle with Jacobson, with Justice C's questions, and you were able to jump off of that. And I don't know if you were planning all of that argument or if you added it as the opportunity presented itself, but that takes very, very quick thinking. And Ms. Borstein, you and I, forgive me, please, for forgetting your rebuttal momentarily. That rebuttal is, arguably the strongest position to be. You had the very, very last word, and you encapsulated the entire case in your comments. Again, I would have liked for you to have, and I know you only had 3 minutes, bringing it back to your client, because your client stands for every single person. But wonderful, wonderful job. I cannot imagine the hours of preparation it took you. And I look forward to the comments from these other judges. And I will say the other judges' questions show an amazing amount of preparation on your part, which is always both intimidating and wonderfully engaging to serve with justices who are well prepared. And I'm going to ask Judge C, just because I see you next to me, to go next.
Certainly, thank you so much. I put some individual comments on the ballot, so I won't go through one by one, but I want to agree, congratulations to everyone. This was an extremely well-matched round. I was very impressed with the advocacy. You always wonder if it's going to be hard to judge these rounds, and this definitely was, and that is a credit to all of you. So thank you. I am a former competitor from this league, and it is really great to see the quality of the advocacy just continuing to improve every year. I also want to note, I hope you all know, I am the least qualified member of this panel. I am not a judge. I am a state solicitor general, so I'm an appellate practitioner. And I know when I was competing here, everyone would say, this rivals the quality of the advocacy that you see in real life. And I am in a position now to echo that. When we do moot courts for all of the attorneys in my office, when we're preparing them for state and federal arguments, the quality of what we saw here today is something that I would be really thrilled to see for many of the cases that we deal with as well. So I want to congratulate you for that. And I think all of you handled these difficult case really well. Obviously, as you know, these are really tough issues, and line drawing is so hard on both sides. And you could tell how much you all had thought through what positions you will and weren't willing to concede. There were some difficult typos thrown at you, and being able to say, this is the position we're taking and why. That is not always easy to do, to think through the implications of your argument. And I see a lot of really strong advocacy from you all in that area. So congratulations to all of you. It's really a pleasure to be able to be here and to judge and to see you all do so well.
Justice Burke?
Thank you. This was fantastic. You guys did a great job. You really did. To judge you with these numerical numbers is almost silly at this point, because all four of you were phenomenal. We are really literally splitting hairs right here, trying to put a numerical value on these things. Excellent demeanor, all four of you. Excellent mastery of the subject matter. This is the championship round. I probably would have expected nothing less. But you did two things. All four of you did two things that kind of stump practitioners once in a while. One is you actually answered the questions that were asked, which is very important and sometimes difficult because you want to stray off into what you want to say as opposed to what the judges want to hear. If a judge asks you a question, you have to answer that question that's asked. And I thought all four of you did a great job with that. And again, I did put some individual comments on, very brief comments on my form, so I won't go into that. But the other second thing that sometimes stumps practitioners is getting back on track after you're done answering a question that was asked. And again, you all did a great job with that. So I had a great time doing this. Had fun with my fellow judges, and you guys should, no matter how this turns out, you're in the championship round. That's fantastic. You should all be congratulated for that.
Justice Carey?
Yes, echoing, of course, what everybody else said. The four of you are all very talented and very bright young people, and should be very proud of your performances. I've judged previous rounds. I think I also judged regionals, and there's a lot of talent out there and a lot of smart people, and for you to have gotten this far really says a lot. And I can tell you, at least on my scorecard, and I think on everybody else's, the difference between first place and second place is very slight. So you should all be congratulated about that. And you have made, I'm a trial court judge, but obviously I hear a lot of argument. I'm in the state of Maryland, but we do, to have any parties or attorneys come for me and be as prepared as the four of you were would be a pleasure. Unfortunately, it doesn't happen enough. Just a couple of things. I think everybody was so good at responding to questions, and really that's what we're trying to do. We're trying to see if we can throw you off. One of the things that happens, I think it happened to Ms. Borstein, was that we were asking you so many questions. I think it might have been Ms. Chowdhury, that we're getting you off of what you want to talk about. But that happens, and it's very important, when judges kind of push you down the wrong way, to bring it back around. And everybody responded very well with their points. One thing I would just say is sometimes you want to be careful about staking out a position that is difficult to defend. Sometimes you go a little bit too far, perhaps on the fundamental right, for example. But as long as you're ready for the questions, that's fine. So the performance that all of you did was really great. I did make individual comments that I understand that you will see, but I hope you all come away from this feeling very good about yourselves, because you definitely should.
So congratulations, you're done. You've lived with this case for, I don't know, what is it, months now. This is the end of that. There's always a moment at the end where Justice Robert Jackson is rumored to have said, I think before he got on the Supreme Court, there's the argument you plan to make, the argument you actually make, and the devastating argument you think of only once it's over. And I've had that experience myself before I became a judge, and you probably will later tonight. But that's part of being an appellate advocate, and you should all be suitably proud of what you did to get to this point. You have mastered a record, and that's true of everybody. And that's the most important thing for a judge, or at least for me personally, is that the lawyer who comes in knows the case just as well as I do, and hopefully better. And so that's the tough part. And then the rest is just little fixes, little tweaks here and there. And you all are so advanced, at least with respect to this case, that I would encourage you, to the extent that you pursue this later during your time where you're at school now, or in particular when you go on to your next school, as I'm assuming many of you will, that you try to refine even more, and you can do that by thinking about themes, and by coming up with different strategies by, as many people talked about, figuring out a way to be responsive and yet get the court to go in the direction you want to go. So there's still room for you to get even better, but you should take away from the fact that what you did today, that you're all really good. So congratulations.
Thank you so much. We really appreciate all the feedback and the judging and the questions. So thank you very much.
Yeah,
Thank you very
Thank
much
you.
for your time. This was awesome. Thank you so much.
Thank you for the college. And I know you're in college or an undergraduate. All 4 of you should consider law school if it interests you. But no matter what's in your future, the communication skills you have are going to take you so far in life. And I'm going to remember your names because I think I'm going to be reading about them in headlines of great successes in the future. Thanks.
On behalf of the American Moot Court Association, I want to thank our judging panel for the final championship round. Thank you all very much for your time and your fantastic participation. This is certainly the best round I've seen in 20 years of doing moot court. So folks, again, announcements will be in about 15 minutes, 4 p.m. Central Time. All right. So you have about 15 minutes. We'll see y'all soon.